In today's video, we will talk about the rights of the accused in American criminal courts. Hello, and welcome to Ask Professor Price. I have been a lawyer for more than 35 years and a full-time professor for more than 10 years. People studying law or criminal justice or working in the legal or law enforcement fields need to know the rights of the accused in American criminal courts so that they do not violate those rights. Violating the rights of a defendant is, in itself, an injustice which a civilized society should not do. In addition, when certain rights are violated, the defendant might be able to keep critical evidence out of court or have grounds for dismissal of the charges. If convicted, a defendant whose rights were violated might have grounds for appeal of the conviction. Let's jump right into the rights of the accused in American criminal courts. The understanding in the American criminal legal system is that crime prevention must take place without the violation of individual rights and liberties. Restrictions on government power take the form of rights granted to the accused. Some of the key rights of accused people in the American criminal justice system include the right to remain silent, the right to have a trial by jury, and the right to counsel in criminal proceedings. We have a concept called due process. Basically, it's fundamental fairness. It starts by a person should always be given notice of any charges brought against them. A person should be provided a real chance to present their side in a legal dispute. And no act of the government or law should be arbitrary or capricious. Please hit subscribe and the thumbs up icon if you enjoy this video. Also, please feel free to share this video with people you think could benefit from the information. YouTube uses the number of subscribers, likes, and shares in its algorithm to determine which videos show up in search results, and the higher these videos are in the results, the more people I can help. Thank you. Now, talking more about the rights of the accused, let's talk about the Bill of Rights. These are some amendments to the U.S. Constitution. The primary ones that impact criminal procedure and criminal justice are the Fourth Amendment, talking about search and seizure, the Fifth Amendment, double jeopardy and self-incrimination, the Sixth Amendment, the right to a speedy, public, fair trial, and the Eighth Amendment, which prohibits excessive bail, excessive fines, and cruel and unusual punishment. This video is an overview of the rights of the accused, so we won't go into great depth on any of these criminal procedure constitutional amendments, but let's touch on each of them briefly. The Fourth Amendment guarantees freedom from unreasonable searches and seizures. So what is unreasonable? Generally, if a warrant is required to search or to take objects or a person, as in arresting the person, if a warrant is required for that search or seizure and the police did not have a warrant or had a defective one, that is usually unreasonable search and seizure. Also, if the police use excessive force or go way beyond the scope of a search warrant, that can also be unreasonable search and seizure in violation of the defendant's Fourth Amendment rights. The Fifth Amendment protects from double jeopardy and self-incrimination. Double jeopardy is not just the second round of a TV game show. Double jeopardy is the concept that a person should not have to stand trial more than one time for the same crime. So let's say that you were arrested and charged with a crime. You pled not guilty, it went to trial, and the jury found that you were not guilty. The prosecutor doesn't get to come right back, file the same charges against you, and put you through another trial, because you already stood trial on those charges, and to have to go through trial again on the same charges would subject you to double jeopardy. Also, the Fifth Amendment guarantees the right to be free from being forced to incriminate yourself. So when someone says they take the Fifth, what that means is they are claiming the right to not have to make a statement that would incriminate themselves. Now, so this would include forced confessions and ordering someone to answer a question when their answer would be detrimental to their status on a criminal or potential criminal matter. Where people misstep is, for example, they'll be in a divorce hearing and one lawyer will ask them a question they don't want to answer, like, did you have an affair on your spouse? And the person sits up proudly and beams and says, I take the Fifth. And the judge will inform the witness, that that doesn't apply in this case. Why doesn't that apply? Well, answering a question about marital misconduct usually would not incriminate a person. Now, if the marital misconduct would be that they tried to murder their spouse, that could be self-incrimination. So they could plead the Fifth on that. But just something that they don't want to say because it might cost them more money in a property distribution in the divorce because of infidelity, that is not an appropriate use of the Fifth Amendment protection from self-incrimination. The Sixth Amendment provides the right to speedy, public, and fair trials. Fair trials mean that a person gets the opportunity to respond to the charges against them and tell their side of the story. Public trials mean that criminal trials are usually not conducted in secret. It creates public distrust in a court system when they hold hearings behind closed doors. Now, sometimes it is appropriate. For example, if it is a juvenile matter, those are done in secret to protect the privacy of the child. But for adults, trials are almost always supposed to be done where the public is allowed to attend. They might have to leave the room during some private portions of a trial, but most of the trial they would be able to watch. And the Sixth Amendment also promises speedy trials. There's a lot of litigation that tries to define speedy, and that's like trying to nail Jello to the wall. But the major takeaway from the right to a speedy trial is that it is considered unfair and in violation of a person's constitutional rights if they are denied bail or cannot afford bail to get out of jail before trial, and it takes years for their case to get to trial. Now, often it takes months. Does that sound like it's a speedy trial? That's a case-by-case question. But speedy, public, and fair trials are guaranteed by the Sixth Amendment. The trick is how speedy, public, and fair are defined in a given case. And finally, the Eighth Amendment prohibits excessive bail. For example, if someone is accused of stealing a loaf of bread, the bail cannot be $20,000 for them to get out of jail temporarily pending trial. That would be excessive bail. Excessive fines are also prohibited by the Eighth Amendment, and an example of an excessive crime would be if the person is found guilty of stealing a loaf of bread and they are fined $20,000 for committing the crime. Cruel and unusual punishment is prohibited by the Eighth Amendment. What a lot of people don't realize is cruel punishment might be allowed. Unusual punishment might be allowed. The issue is a particular punishment meted out to an individual convicted offender cannot be both cruel and unusual. One might say that having to spend even a day in jail is cruel, but that doesn't make it violate the Eighth Amendment. One might say that having to do repairs to a home after vandalizing it is unusual, but the Eighth Amendment would not prohibit that because it's unusual. Why? Because it's not also cruel. Okay, that's a brief overview of the rights of the accused in the American criminal justice system. Please feel free to post in the comments your questions about criminal law or related topics that you would like to see covered in a future video. I cannot provide legal advice about specific cases or situations, but I can offer general legal information for educational purposes. Law students, paralegal students, criminal justice students, and pre-law students, as well as people working as paralegals or in the criminal justice field, are the main audience for these videos, but everyone is welcome to learn about American law and our legal system. Please remember to subscribe so you can get notifications when I post a new video. Subscribing will not cost you anything, but it can help me to reach and help more people with these educational videos. Thank you. If you liked this video, you might like the next video called Criminal Elements, or What is Corpus Delicti?